The Portfolio Committee on Public Works and Infrastructure has extended the deadline for written submissions on the Expropriation Bill to Sunday, the 28th of February 2021. Now, the committee has invited stakeholders and interested persons to submit submissions on this version of the bill. The purpose of the bill is to review the existing Expropriation Act 63 of 1975 and to provide a common framework in line with the Constitution to guide the processes and procedures for the expropriation of property by organs of state. Joining me now to unpack this is legal expert, Advocate Toby, researcher at the University of the Western Cape's Institute for Poverty, Land and Agrarian Studies, Professor Ruth Hall, co-leader, Monsieur Lekota, and project manager at the Institute for Race Relations, Terence Corrigan. And of course, so we'll also be taking your views in this conversation. You can tag us at Newzroom 405, or you can send us your WhatsApp questions and comments on 072-110-5584. Good evening to you all. Let's all unmute and hopefully we can hear each other. It's good to have you with us.
Thank you.
Thank you. All right, Advocate, I'm going to begin, I suppose, with you, and this is a question that I'm going to put to all of you as opening comments generally to our conversation today. What do you make of the latest developments? I suppose they're pretty much related to the COVID and the pandemic we're dealing with. There's an extension, but also broadly in terms of this bill now being before Parliament. Was this necessary? Were the amendments necessary, Advocate?
Yes, the amendments to the Expropriation Act are clearly necessary. We've got to look at this from a historical perspective. And in relation to broad history, the central element of the colonial occupation of the place now known as South Africa by people that came from Europe, in Holland first and then later from England. The prime signature was the dispossession of land. One of the mechanisms of the enforcement of that dispossession was to install certain laws and statutes. One of those laws was the expropriation legislation. The very last piece of legislation was passed in 1975, known as the Expropriation Act. It served narrow state interests, often in conflict with property rights of African people. Once we had a new constitution in 1994, subsequently passed into final form in 1997, it became necessary to align the 1975 legislation with the Constitution. So it comes more than 25 years after the Constitution came into effect, but it is absolutely essential and necessary.
All right, I'll come to you on what you mean by narrow state interest in just a moment. But Professor Ruth Hall, what are your views on the amendments to the Land Expropriation Bill? In fact, Advocate Toby, you'll comment on this as well. At some point during an interview with the public broadcaster, you said, well, you kind of think it's a thoughtless exercise because you don't really need to make those amendments in order to expropriate land, but it's government wanting to look like it's busy doing something, but when they're actually not. Professor Ruth Hall?
Thanks so much, Thabo. I really welcome this opportunity because I think that many people watching this debate must be thinking, well, there's a whole discussion about changing the Constitution and the property clause in the Constitution to make provision for expropriation without compensation. What we're talking about now is actually not the constitutional amendment. That is still on the cards. It is still to be discussed, and there is an ad hoc committee in Parliament looking at that. That's actually entirely separate from this bill that is now being brought. This bill, I agree, is absolutely necessary because it brings our law in line with what was negotiated in the 1990s. So in the 1990s, there was a discussion about how do we have a system of property rights in this country that does not insulate and give priority to those who happen to be the private owners of land. and to give a clear mandate to a new democratic government that it must embark on land reforms, it must redress injustice. And to do so, effectively, our constitution sets up a set of property rights for the propertyless. It actually says that people who were dispossessed or people who have no access to land have a right to property. But the state cannot realize this right if it is to tiptoe constantly around the rights of existing property owners. So where we have a direct conflict between the rights and interests of those who own property and the rights and interests of those who were dispossessed in the past or who are landless now, the state is impelled to take action to promote greater equity and justice. But it can't do so unless it can break deadlocks by expropriating. And a good example is where there are land claims where for more than 30 years, people have been, for nearly 22 years, people have been waiting for their land claims to be processed. If the state cannot expropriate, then it means the interests of the current owners always take priority. So I think that expropriation is absolutely necessary. And the debate is about on what terms and with what compensation. And that is where I think on this panel, we're not likely to entirely agree.
All right, Terence Corrigan, let's bring you in here. Is this conversation, this debate around the Expropriation Act necessary at this time? And do you feel it in any way infringes on property rights?
Well, the first point, I think, is to agree with what Professor Hall said, that they're disparate processes. Okay, and I think it is important to recognise that the constitutional amendment and the Expropriation Bill are separate. But I think we can go beyond that. The Expropriation Bill is not just about land reform measures. This is about effectively, and let's say more narrowly, the terms on which the government can take people's property. That is a matter, I think, of profound importance, and we as the Institute and myself personally have been on the record as saying that we oppose what the law is proposing. As to whether we need a new expropriation bill, well, yes, the 1975 one is not in line with the Constitution, but we also believe that there are constitutional problems with the current draft. So yes, does it infringe on property rights? Well, any act of expropriation is going to. And this is, something that often find myself having to explain with people who, let's say, as Professor Hall said, probably agree with me more than disagree with me, that there is a place for the state to expropriate. It happens in all countries. It's, let's say, a necessary evil, if you like. It is a tool of policy. Whether you want these particular terms and these particular powers vested in this particular state, though, that is a matter, I think, of some controversy.
All right, let's take a break at this point, because what I want to come back to then with Advocate Thembeka Gcukaitobi, and we've got Ntatemiso Lekota as well joining us, will come in after the break, is just break that down. You've got the property rights, which is a big issue. Then you've got the Constitution, and you've got the 1994 settlement. Which of these actually prevents government at this particular point from expropriating land the way that government wants to expropriate land? And in some instances, they've voiced that there are instances where they would like to expropriate without compensation, but previously we've known that they've adopted the willing buyer, willing seller principle when it comes to the expropriation of land. Professor Ruth Hall, and Ntatemiso Lekota, as well as Terence Corrigan. Ntatemiso Lekota, let me start with you and give you an opportunity to tell me what your views are on the work currently underway in terms of the amendments to the Expropriation Act 63 of 1975, which we know it's not the same thing as the amendment to the Constitution. What is your feeling about this process and whether the amendments are necessary?
Yeah, the amendment which act?
The Expropriation Act 63 of 1975.
Are you talking about Section 25 of the Constitution?
No, I'm not talking about Section 25. I'm talking about the Expropriation Act 63 of 1975.
Well, I always proceed. I think this whole land debate issue proceeds from Section 25, because Section 25 does not speak about, it's not aimed at land alone. It's aimed at property in general. Land being just part of property. Now, and what it does say is to accept that we attained freedom at a time when various people owned different types of properties. Others owned houses, others owned cars and whatnot. And that's why it speaks about property. And where it talks about certain specific things, it will identify those and it will say about that.
Yeah.
Now, I've never made it a land issue, a specific item that we can take anybody's land just because land is property like anybody else's property. Now, if you want to take my land, you'd have to look at as to how did I come to own that land, and what you do with that is as good as what you can do with my house or my car.
Yeah.
Now, as far as I have understood the property right is that when we attained freedom, various people had various types of properties. And we would respect that, because if we were going to try and take things from other people and all of that, I think we'd just throw the whole country into a mess in which people just kill each other for nothing.
Right.
So I don't know what you would like me to say.
No, it's fine what you've just said. We'll expand on it a little bit more in a moment. Advocate Tembeka, let me bring you in here. When it comes to the land question, whether we are talking Section 25, whether we are talking the Expropriation Act 63, but particularly when we're talking about the question of expropriation without compensation, your view is that we should always have this debate from a point of being quite expansive. And not just look at the compensation question, but look at other avenues that are actually currently available as far as the Constitution is concerned, be it Section 25 or Section, 26, or what we currently have in terms of the powers that are vested in terms of judges and the judgments that they can pass. Now, Tate Msolekota is raising the question of, it is important in the question of expropriation to ask the how did one, acquire the land. Two, what is on the land, whether it's just the land or there's agricultural produce or whether there's property on the land, and that should be considered as well as we address this question. Put that in context to me in terms of property rights, in terms of the Constitution, and what the settlement was in 1994.
Yes, thank you. Perhaps I should just clarify the parameters, certainly, of my input in this respect. So firstly, expropriation is a power given to the state to take away property without the consent of the owner. And that flows from the principle that ordinarily, when you are an owner of property, you hold that property to the exclusion of everybody else. There are then certain circumstances where the state may justifiably interfere with your ownership of property. In post-colonial states, this is a very controversial question. The reason why post-colonial states are particularly and peculiarly affected by the problem is that the unique feature of colonial conquest is that the occupying power takes away property, particularly land. Most countries that emerge from colonialism have to grapple with how to undo the consequences or the legacies of conquest. Some countries implement nationalization. Every state, every asset or land in particular is simply nationalized. Others do not. Other countries still pass laws. We fall into a category of those countries that are governed primarily by law. Our law enables the state to take away property, particularly land, sometimes for its own usage. So for instance, if it wishes to build a road or to build a school, sometimes, which is mostly where the debate is, sometimes for wider public distribution. In other words, to give it to people who ordinarily are unable to acquire the land in the so-called open market.
Yeah.
And this is where the controversy is. On what terms should the state forcibly take away land of a recalcitrant landowner? What compensation ought to be paid, if any? What procedures ought to be followed? Under Section 25 of the Constitution, the state was allowed the power to expropriate land in particular for land reform purposes. But trial and error, 26 years into democracy, the state has been extremely recalcitrant to implement its expropriation powers. One of the excuses it has been giving is that it does not have legislation. This bill is intended to give the state the legislative framework to implement the taking away of property. One of the elements of this bill, which has been one of the more controversial elements, is whether or not the state should compensate at market value, below market value, sometimes at zero. The Constitution itself gives no guarantee to market-based or market value compensation. It refers to just and equitable compensation. But state practice, which is not the law, state practice since 1997 has been to compensate at market value. An article I read, I think from Professor Ruth Hall, suggested that the source of that decision was a World Bank recommendation in about 1996, which the government has ultimately endorsed into policy. I saw this recently in the white paper on land reform passed in 1997. And so state policy has always been inconsistent with the Constitution. One of the aims of the bill, and I don't argue that it fulfills those aims, one of the aims of that bill is to remove state policy that is fixated at compensating into a flexible compensation regime that focuses at just an equitable compensation. But there's still a big question as to what is the content of just and equitable.
Yeah. Professor Ruth Hall, how did we get to this point of government practice of paying willing buyer, willing seller? No, it was the policy of government in the early 90s. They've since seen that it doesn't work and have attempted to move away from that practice, but that has received a lot of backlash.
Yeah, isn't this an irony? I recall that when I was a graduate student in the mid-1990s, the Constitutional Assembly was having public hearings on the property clause. And there we had a number of think tanks supporting private property rights, opposing any provisions around expropriation, or demanding that where there is expropriation, there must be market-related compensation. Each case must go to court and so on. And, you know, if we look at what happened, that private property lobby lost the argument in the 1990s. And at the time, it was the ANC and particularly the Pan-Africanist Congress that argued that there must be provision for expropriation in the public interest. This includes land reform. It's about promoting justice. And yet we see that for all these years, these intervening years, the state has chosen not to use those powers. And so the interesting thing, of course, that now is that a couple of years ago, a motion in Parliament said we should look at changing the Constitution. And suddenly those who oppose expropriation jumped to defend the Constitution. and to say, no, let's leave the Constitution as it is, it's adequate. But now that we have an expropriation bill that tries to give effect to the Constitution as it is, they're opposing the bill. So I think that we need to be clear here. The state has never used the powers that it had under the Constitution. And I don't think that any of us on this panel would pretend that the state has tried to give effect to its constitutional powers to embark on meaningful land reforms. So we might share a skepticism about the state, but that's not to say that the state should not. I'd like to suggest that, in fact, what the expropriation bill does is necessary, but it's not enough.
Yeah.
In fact, the problem is not the state having inadequate power. The problem is that people who are landless or dispossessed or waiting for their claims to be resolved haven't had sufficient power to oblige and push the state to act on their claims. That's been the primary factor holding us back, and that's a political challenge rather than a legal one. But I want to make a very pointed point that those who are opposing the expropriation bill now, often on particular procedural grounds, are by and large wanting to hold back the process, which could lead to greater certainty and greater progress in the future. And I think that, the danger is that people are fighting a battle that was lost a quarter of a century ago. And I think that now the question is, how can government be pushed to use its expropriation powers in the public interest?
Terence, bring you in here. Those who are opposing the expropriation bill are fighting a battle that was lost at least decades ago. And quite honestly, this is what has, in a sense, slowed down the pace and the process of land reform. I mean, we're talking here 7 to 8% of the land that has been taken back to the people when government had set itself a target in 1994 of close to 30%. What's your reaction?
Well, look, I think that land reform has just never been a state priority. I think that is probably where the kernel of this comes in. Any government needs to prioritize, and land reform, particularly on the agrarian side. I think the urban situation is somewhat different. Has never received meaningful budget allocations. You have an incapacitated bureaucracy. Government itself won't dispute this. My concern, though, is that this could spiral out of control very quickly. And as I said at the beginning, do you want this government to have these powers? Are these the terms in which you want this law to be exercised? We have particular concerns, for instance, about the link between the act of expropriation and the payment of compensation. And I don't think we're alone in that. We are concerned about the definition of expropriation, which seems to allow a fair degree of latitude for the state to deprive property without that counting as expropriation.
Yeah.
So as I say, the goal of land reform is one that I support.
Yeah.
I don't have any issues with that. I think the particular methodology that's being pushed at the moment, though, is not likely to be productive.
Advocate Goaitobi, do we want governments to have these powers? I suppose you'll argue that the Constitution gives government these powers anyway, and they were just supposed to have used them and applied them.
Yes, we've got to separate two concepts. One is the act of expropriation. The second is the act of compensation. The Constitution grants the power to expropriate on the state, on the government, on Minister Patricia de Lille and Minister Thoko Didiza. Those are the people with the power right now under the Constitution, which institutes like the IRR say they support. But they cannot use the bill to try and win a debate that they didn't win when the Constitution was enacted. The second act is the act of the decision as to the compensation. The Constitution says that is not a decision of the government. It is a decision of the judges, of the courts. The expropriation bill doesn't change that. It still retains that function under the designation of the judiciary. What the expropriation bill makes clear is that the act of the expropriation, as a consequence of that act, the property expropriated vests in the state. You can then go and fight your debate about expropriation. That is currently the law as decided by the Constitutional Court in a case called Hafeji, that there has to be a separation between the act of expropriation and the payment of compensation. And that is a good thing. Let's make this clear. This is a good thing because claims of expropriation, typically, in my own experience in sitting in the Land Claims Court, claims of expropriation, particularly in the context of labor tenants claim, tend to drag on. I once presided over a case that had dragged on for 15 years. So the separation between the expropriation and the payment of compensation is a positive thing for land reform.
Lekota, I'm going to come to you. The Expropriation Bill, a separation of the Expropriation Act itself, which the legal experts are saying is already in the Constitution. It already gives the state that power to expropriate. But separating that and the decision for compensation, sitting with the judges, that it's the judges who will decide what a fair and just compensation will be, and maybe even at point decide that the compensation is nil. That is a good thing, is it?
So you know what? One thing that all of us seem to ignore is the fact that land is not in its origin. It's not just, you can't just say this land is worth so much. It is when people employ that land for certain things that they begin to give it value. Now, very many people were settled on all the lands that were here in this country, but since they did not dig gold and gold was not an issue, they didn't mine gold. They didn't give the value that gold gave it. Once gold was discovered, it assumed that its value, high or low, depending on that. If we identified a piece of land that is appropriate for building a dam, suddenly and overnight, that piece of land assumes a certain higher value than when nobody was thinking of building a dam on it. And the reason, therefore, the questions of expropriation becomes contentious is to what use is this land, can this land be put to?
And are you saying that that should determine the price that a government pays for that land?
I'm not saying that it should. I'm saying that is what gives it the value. People decide that this is very valuable land because it can do certain things. Before the advent of the Indian people when they were brought here in KZN, that was before people discovered that those hills of KZN and so on are appropriate for sugarcane cultivation.
Yeah. Once
that was discovered, people now bought those lands and they did that. Now the value of sugarcane growing on it, transformed it into a very expensive property. Okay. Similarly with the wines and all of that.
Right.
And today we are discovering in what looked like just ordinary dry territory, we are discovering manganese, we are discovering other things. And value arises from that. It's human beings who look at land, what it can be done, and they give it that value. And we can't escape it.
Okay. Professor Ruth Hall, I hope you're following what Ntatabiswa Lekota is saying. He's saying, how do we determine the value of the land? Therefore, how do we determine what the compensation will be? It arises, he says, from what we discover the land can be used for. If it can be used to build a dam, if it can be used for a sugar plantation, if it can be used for wine farms. And therefore, that will determine what value we should pay for that land.
Well, yes, that would influence market value, absolutely. But let's be very clear. The Constitution does not say that market value must be paid as compensation for expropriated property. It explicitly says that all relevant circumstances should be taken into account to determine just and equitable compensation, including how the property was acquired, how much the state has subsidized it, its current use, the purpose of the expropriation, and the market value. So at least those 5 criteria should be taken into account. Now, here's the thing. Nobody knows and just and equitable compensation, because this piece of legislation was first gazetted in 2008. There was an uproar from private groups, think tanks, the Democratic Alliance, and other groups. The F.W. de Klerk Foundation and I believe the Institute of Race Relations also opposed that bill. It was withdrawn. It came back in 2013. It was withdrawn. It came back in 2015. I was passed in 2016, was withdrawn. 2018, gazetted in 2019 and in 2020. So if you want clarity about what constitutes just and equitable compensation, we have to support this bill, allow the process to happen. And we can all be sure here that property owners and the think tanks that support private property interests and oppose expropriation will be contesting these in court. And we will have a chance for the first time to hear from the Constitutional Court what is a reasonable approach to compensation. I think the key thing the government could do now is to lay its cards on the table and say, here is an approach. If somebody bought property through the market 10 years ago and is using that and it's their primary asset, here's how we will approach compensation. If it was 30 years ago, 100 years ago, 200 years ago, if here's how much subsidy has been provided, if here's how it's being used now, here's how much we're going to offer. So I think what government needs to do is to say in certain situations, no compensation. In some situations, perhaps market kind of price is reasonable, and perhaps a whole spectrum in the middle. Bear in mind that the law and the approach to compensation has to address all situations. This is a law that would apply equally to an individual or corporate owner of commercial property. It would apply to a community in the communal areas, for instance, communities in the Platinum Belt or Kolobeni on the Wild Coast, who are opposing mining on their community land, subject potentially to expropriation. How should compensation be approached? So I think that what we need here, we need this law, and we need to have policy clarity about how government wants to approach compensation and how it defines what is just and equitable. And then we need to have both a legal and a political process around this issue. But I think the starting point is to get this bill enacted into law, and particularly to pay attention to the situations of poor and marginalized communities who stand to be expropriated, who might be very difficult to engage with the legal process. So I think that that's an issue that also needs to be remembered.
Prof. Ruth Hall, let's hold it there. Let me get some comments on WhatsApp tonight. Let's have a look at what you're saying. You have been engaging, of course, with some of the thoughts being raised here tonight. After 26 years, we're still talking about land reform. A huge number of young people do not have land. I suggest that the government must develop a train those who will be farmers in a true or develop and train, rather, those who will be farmers in a true sense of the word after this land has been reformed. We need food security strictly in future in this country. From Mazingi Sabongane Bizane in the Eastern Cape. And from Veli saying, why should there even be a discussion on the need for the return of land to its rightful owners, the African people? And why was there a liberation struggle in the first place? It was all about land when the Europeans dispossessed us. Did they consult us? That's Veli Mbele there on WhatsApp sending us those thoughts. Advocate Tamara Toby, let me engage you on that. And Professor Ruth Hall has raised this a little bit already. This is from one of the lead researchers from the Land and Accountability Research Center saying there seems to be a lack of understanding on when it comes to land rights under customary law and land tenure rights. They are not understood by state and private institutions. In fact, they're saying, for example, the issue of mining rights. Government gives mining rights to mining companies without deriving those rights from the communities who own the land. And those communities are the ones who need to then determine the compensation or even the value of that land based on whether it is what is being farmed on there, whether it is their spiritual rights, whether it is their ancestral rights on that land. How do we navigate that legally?
Yes, I mean, that's a very, very important question. And you know why it's important? It's for two reasons. The first is that there are in this country more than 26 million people that live under a form of traditional leadership, under a form of customary leadership. The second reason why this is important is that the nature of the rights that they hold over the land are often very, very tenuous, often subject to arbitrary power of chiefs, headmen, and traditional authorities, and often subject to governmental authority over their land. So you are dealing with a large group of people, and B, with very tenuous and vulnerable hold over the land. And most of the debates what we have on the draft bill, Section 25 of the Constitution, tend to focus on the rights of the propertied, not the rights of the propertyless. But by introducing so-called informal land rights holders into the discussion, one begins to see a much broader appeal of the space for land reform in this country. On your specific point, which is how does one navigate the question of persons living under informal land systems? The first question that has to be answered in that respect is how do we strengthen the rights of persons customary or traditional leadership systems? Often people argue that the way to do it is formalization. Formalization might also produce negative outcomes because of its exclusionary nature. My own preferred view is the strengthening of the existing rights in a communal setting and the recognition of those existing rights by law. We currently do not have a system that strengthens and recognizes those rights by law.
Right.
Secondly, it is to make clear that the power over the land does not reside with the traditional institutions. Let's make this point again. The people own the land, not the chiefs. In this country, there is a tendency to appropriate land belonging to family, to communities, and to individuals,
right,
and to concentrate the land on the chiefs. It is crucial when we talk about genuine, sustainable land reform to separate political control of the chiefs to the control over the land.
Right.
So if we made those two elements clear, one is the separation of political control over the land control, and the secondly is the clarification and the strengthening of those rights.
Right. Advocate, we are out of time, so Terence, I'll give you the last word here on the question of how we approach just compensation.
Look, I think that this is a problem that's going to be with us for a long time. My preference is for market compensation to be the basis, but I would to take up the point about informal rights and about people living in traditional communities. I think that is absolutely crucial. And while I understand the concerns about formalization and titling and the risk that it does pose, I do think that some sort of process that will allow that to develop over time would be a very good idea. I think this has been one of the great failings of South Africa since 1994. The neglect of people living in that sort of tenuous tenure arrangement.
All right. Unfortunately, we are out of time. We'll never exhaust all the points, but it will be good to have this conversation again at a later stage. I appreciate all of you for coming on. Advocate Tembeka Ncugaidobe, Professor Ruth Hall, Monsieur Lekota, as well as Terence Cadigan. And I appreciate you for sharing your views as well tonight.